Well, hello, everybody, and welcome back to your favorite show on the internet, Raw Law Unfiltered, with your favorite host, the DUI Guy. Plus, today we are going to be talking about more Jeremy and George with What the Hales. You guys, this is absolutely unbelievable in an unprecedented move, in an unexpected turn of events. I don't want to jinx it, but I think they've won. The first district in the Court of Appeals in Tallahassee, Florida, has ruled successfully that they are going to uphold Randy and Doreen's motion if Lynette does not give a good enough excuse as to why Judge Craig Constantine the Thomases should remain on the bench. She has 20 days from May 15th, 2024. So what does that all mean? Let's unpack the order, okay? The order is very, very short. It is only 2 pages, and we don't even need to go through the 2 pages, really. All the text, the meat of this order is located directly at the very, very beginning. At the very, very beginning, let's take a look. District Court of Appeal, 1st District, 2000 Creighton Drive, Tallahassee, Florida, May 15th, 2024. So this is fresh off plate, folks. This is straight out of the microwave. It's hot. It is juicy. It is still steaming with the delicious aroma of victory. Jeremy B. Hales, the petitioner, versus Lynette Preston, the respondent. We have a case number, etc. By order of the court. This is the Court of Appeal, right? Remember, let's take us back. For those of you who may be wondering, wait a minute, what is this in response to? Because we have so many things going on with the What the Hales. This is Randy and Doreen's motion that they filed on March 1st at 6 a.m. Remember that one? A writ of prohibition to remove Judge Craig Constantine de Thomasis from Jeremy Hales' case. Okay? So that was filed, and then Craigie went, okay, laissez-faire. I don't even do this. I don't need this. I don't want this. This is not for me. Because he was stripped of jurisdiction, he was devoid of power, and now, the Court of Appeals, we're waiting. Remember, we thought this could take 6 months, 9 months. You never know how long a Court of Appeals could actually take with these motions. So it's quite infuriating sometimes to have to sit there and wait. But thankfully, this is one of those situations where we only had to wait 2.5 months. To me, that's pretty fast. March, April, and half of May. That's really fast. It's actually exactly 2.5 months if you count, all of April, and it started March the 1st. So this is good. This is really good. 75 days is not bad at all for a Court of Appeals. By order of the court. So what does it say? The respondent, Lynette Preston, she's the respondent, shall, that's a must, she must show cause. What does that mean? Oh, they've already made their decision. Now she needs to show cause why their decision is improper, if she believes it is. The respondent shall show cause why this court, the Court of Appeals, the 1st District, the Court of Appeal of Florida, should not issue the writ of prohibition requested in the petition docketed on May the 1st, 2024. The respondent shall serve the response within 20 days from the date of this order. So she has until June 4th, 2024. If June 4th rolls around at the end of the day, June 5th, 2024, if there is no response in the court's possession, they're just going to grant the writ of prohibition that Doreen and Randy filed back on March the 1st. The respondent, Lynette, shall serve the response within 20 days from the date of this order. And the petitioner then, if there is a response, the petitioner, Jeremy, may serve a reply within 20 days thereafter. So meaning whatever that date's going to be. So if she waits until the last minute, we would have a motion from both sides no later than June 24th. It may come much sooner. Like, let's say she files a motion to show cause on May 22nd, hypothetically speaking. Well, then Jeremy would have until whatever that would be, June 11th or whatever it is. Just count 20 days, basically. But no later than June 4th. If Lynette misses that deadline, then the court is simply going to grant the writ of prohibition that Doreen filed and has written. Now, one thing kind of puzzles me, and I think some people were raising their eyebrows and asking questions as to what the heck is going on here. Like, why are they doing this? And this is kind of fascinating, I've found, since the court, I think, was waiting, potentially, we don't know, I can't say for sure, but they were waiting for Lynette to file a response to the writ of prohibition that Doreen filed. But because Lynette is not a litigator, she's not an attorney, she's barely represented by one. All offense to Silverman, by the way. The question really becomes, why didn't she? Well, maybe she didn't know to file a response to the show cause order. Maybe the court just wanted to give her an opportunity because she's a pro se litigant at some point. We don't know. This is very standard. This is absolutely very, very standard. And we have the entire answer in that first paragraph. And again, I'll read it to you. The respondent shall explain, show cause. And I could actually, you know what? I'll read it in human language so that you understand what the court is saying. The respondent must explain why we should not remove Judge Craig Constantine de Thomas's. You have 20 days to respond from the date of this order, and then Jeremy has 20 days to reply to you. That's it. That's all it says in pure human language. Now, the rest of the order is simply going into some of the additional details. So the court grants in part the motion docketed March 6, 2024, and the court accepts the following portions of the supplemental appendix docketed March 25th, 2024. The transcript of the January 23rd, 2024 hearing, and the remainder of the supplemental appendix is stricken. Now, this part is a little weird. For some reason, the Court of Appeals in the First District of Florida decided that they are going to accept the January 23rd, 2024 hearing, but they're going to strike all the other courtroom videos. They don't care, apparently. They only care about that one. To them, you know what that tells me, actually? That tells me that that one video was enough for them. They don't even care about anything else. To them, just the video of the January 23rd, 2024 hearing and Judge de Thomas's behavior in the courtroom is enough. They don't even need to go further. They don't care. That's actually pretty big. The more I think about it now as I'm recording this video for you all, that is really, really big. The court, that paragraph, accepts the amended petition docketed March 25th, 2024, because if you remember, Doreen went back 3.5 weeks later after she sent the original petition. She moved to amend it because she wanted to polish it, make it nice, make it clean. I mean, she's a professional, you know. Doreen is a professional attorney who values her integrity, who has a reputation to maintain. And the fact that Judge de Thomas's gave her less than 48 hours to submit a petition that took her 3.5 weeks to correct, I mean, it gives you an understanding of how barbaric Judge Craig Constantine de Thomas's has acted towards Doreen and Randy. And so the court said, no problem. We will accept your amended petition docketed on March 25th, but any specific reference to any other supplemental appendices are stricken and will not be considered. What does that mean? Again, it's back to the second paragraph, right above it. January 23rd, 2024 video is the only one that we care about. That's the transcript. The transcript, we didn't really care about the video. We want the transcript of the video. That is enough for us. The court denies as moot the motions to issue a show cause order docketed March 1st and 4th. So that's removed. And they certify that the foregoing is a true copy of the original court order. And it was served upon Judge Craig Constantine de Thomas's, Mark Feather, since he was still on the record at the time, Doreen Inkleys, Randy Shockett, Christy Lopez, and Josh Silverman. And it's signed by Krista Samuels, the clerk of court for the First District Court of Appeal for the state of Florida. There you have it, folks. I mean, you can't make this stuff up. This is great. To me, this is great. I can't think of any possible universe where Lynette is going to win this. I'm sorry. I'm calling the bluff. I know you guys don't have faith. I know you all think. I read your comments because I posted this on my channel, on my channel's community page, and I saw and I read your comments. And some of you really don't believe that this is going to succeed. As a professional, respectfully, I disagree. What this shows to me, the language that the court uses, the respondent has to show cause why we shouldn't agree with Jeremy. And the reason that they're agreeing with Jeremy is one hearing on January 23rd, 2024. That's how horrible that hearing was. It was enough for the court to consider. And to me, I think their decision is already made. They're just giving Lynette one last opportunity so that she doesn't have an issue on appeal to say, well, I didn't have a chance to respond, being a pro se litigant or whatever. They're giving her a chance. Hey, lady, would you like to respond to this? and she has 20 days. Clock's ticking. Today, as of the date of this recording, it's May 16th. Tomorrow, when this video premieres, right after the Jeremy and George video at 5:30, mine is at 6, half an hour later. So she'll have 18 days. From the moment this video premieres, she has about 18 days, if not 17, to respond. Will she respond? Probably. Will it be anything of value? Maybe. Will it have an effect on the court's decision? I don't think so. So I hate to jinx it, but I think the decision is already made. They just need to go through formalities. Feel free to disagree with me, but that's my opinion, and I'm sticking to it based on my experience, knowledge, and expertise in the legal arena. So I wanted to thank you all for joining me. I hope you all learned something. Power to Jeremy and George. I mean, next steps are we're going to get a new judge. I mean, we lost sight of the original ideology in this whole thing. We are going to get a new judge. The Thomases is going bye-bye. Wave goodbye to Craig Constantine, the Thomases. No more badgering Jeremy. You're going to be replaced by another judge, maybe in another jurisdiction. Maybe they'll bring in a special judge to the same courtroom. I imagine, any of those is possible. And hopefully in about, I don't know, a month or two from now, we'll have a new hearing. Maybe in July, maybe in August, there'll be a brand new hearing. So I'm very excited. I think it's time. Jeremy deserves his day in court with a judge who will listen and who will listen to him and his lawyers. And Craig, good old Craigie, is clearly not it. So I will see you all in the next video. Don't forget to subscribe to the channel if you haven't already. Every day, 6 p.m., new video. And next, by the way, coming up, you're going to see my associate who tried a case last month, and that one is going to be premiering over the next week and a half or so. It's a pretty long one. It was a long trial, and it will be broken down into about 8 pieces. So bear with me as we premiere it, and then we will go back. And of course, more Karen Reed content as well. And Alec Baldwin, be on the lookout. I'm going to be making an Alec Baldwin video. Filed another motion to dismiss. His lawyers did, of course. One more thing before I forget. Craig Hendry and I are going to be doing an interview, and that will be premiering on my channel probably next week as well. So be on the lookout for that. I love every single one of you, and I will see you all in the next video. Goodbye, everybody.